this computer. All right, everybody, this is the transcript from June 26, 2015. And our characters are, there's Reed Randoy, that's the petitioner. There is Judge Tamara Hall over here. There's Nicholas Salick, the attorney. He's going to show his face in a sec.
I'm not a crook.
Huh?
I was making a
Oh,
Nixon
okay, sorry.
joke. I'm not a crook.
I know, you're not a crook. You're not a crook. And we've got Casey, who's the court clerk. All right, I'm going to share my screen for a sec. Okay, so I'm the narrator in this. It's just, you know, this is case number BD 621-137. It's case name Reed Randoy for petitioner versus Marieke Randoy respondent. It's in Los Angeles, California, Friday, June 26, 2015. Department CE 22. The Honorable Judge Tamara Hall, judge. Reporter Barbara A. King, time 11:05 a.m. Appearances, the petitioner Reed Randoy, present with counsel Nicholas A. Salick, attorney at law, the respondent Marieke Randoy, present in propria persona. All right, it starts with the court.
Okay, that's me.
No, that's the court is Judge Tamara Hall.
Good morning, everyone. Number 21. Randoy versus Randoy. Appearances, please.
Good morning, Your Honor. Nicholas Salick for the petitioner, Reed Randoy, who was present at council table.
Marieke Randoy.
Thank you. If you could swear the parties.
Please raise your right hand. Do you solemnly state the testimony you may give that causes now pending before this court shall be the truth, whole truth, but nothing but the truth, so help you God?
I do.
I do.
Oh, sorry. Carry on.
Okay. You may have a seat if you wish. We're here today regarding an ex parte that was filed on June 5th, 2015 by the petitioner. The court reviewed the ex parte and granted temporary sole legal and sole physical custody of the minor child, Hunter Randoy, to the petitioner with no visitations to the respondent, pending this court hearing to give the respondent an opportunity to be heard. And just one moment. The court has reviewed the respondent's declaration. Responsive declaration filed June 17th, 2013, and the attached exhibits, and no reply was filed no later than June 19th, 2015. So I will first hear from the moving party, and then, ma'am, you will be able to address any points that they make afterward, okay? Counsel, you may be heard. Mr. Salick.
Thank you, Your Honor. First and foremost, I want to go through the procedural issues that we see. First and foremost, the court should know that the petitioner does not have custody of Hunter. The respondent never returned Hunter to the petitioner, and the travel documents weren't returned. And she concealed Hunter from petitioner and recently blocked petitioner's telephone access to her on her phone and blocked his access to the minor child on Father's Day. With respect to, first of all, the responsive declaration of the special appearance, responsive declaration wasn't filed on the mandatory FL 320 judicial counsel form. Also, it was filed and served late because per the ex parte orders, it was supposed to be filed. Actually, it says served, but served by June 15th. It was filed June 19th.
17th.
June 17th, and then my office received it June 22nd, which was why there was no reply, because we didn't have anything to reply to until we actually physically got it on June 22nd. With respect to the challenges to this court's jurisdiction, that's moot. And it was made moot by respondent when she filed her response to the petition for dissolution. essentially accepting and agreeing to this court's jurisdiction over both the divorce case and Hunter. We don't take it very lightly, the fact that she is in violation of every order this court has made that was made ex parte on June 5th. And in response, she's asking for her own relief. She's asking for various types of relief. She does not want the court to have jurisdiction over this case. She wants sole custody. She wants permission to move. She wants a court order allowing her to stay up in Vancouver with Hunter. Without. I could go into the substance of that, but that's not why we're here. It's not a jurisdiction here. But again, the proper procedural manner to contest jurisdiction is by filing a motion to quash within the 30 days after being served with the summons of petition. Instead, she chose to file a response. She didn't file a motion to quash, and she responded. I don't know if the court read any of the documents that were filed today.
No, because they were late.
Okay.
I didn't receive them. They were late.
Okay. So I think first and foremost, we need address the fact why respondent is not complying with the court's ex parte orders.
Okay. Wish to respond on why you failed to comply with the June 5th, 2015 court orders?
Your Honor, I wanted to be here for that hearing. I did my very best to get here to that hearing, but my husband, who controls the bank accounts, has cut me off financially. I have evidence to show from text messages that I pleaded with him to let me and Hunter get on a plane the night before to get here. And the extra documents that I submitted this morning, and I apologize for them being late. I'm self-represented. I have no money. He's cut me off completely. The day that I was notified of the ex parte is less than 24 hours notice. But I was able to call the Family Law Help Center, and the following week I was able to find out what actually happened at the hearing and respond to it as quickly as I could. It wasn't complete because it wasn't enough time for me to do it, but I have since given just overwhelming evidence that the petitioner is misleading the court. I'll just start with the fact that on the original divorce petition, when he first served me on May 21st, he states our address. Our home address is being Vancouver, Canada for over a year, and that the three of us live there. Do you need to know where that is?
No.
Okay. He also states that his address, he misleads the court by saying that his address is actually a UPS mailbox. But what's important to note is that he states that the child has lived there for the past year at this UPS mailbox, when in fact, when we first came down to visit on April 25th, Hunter, our son, had not been to California in over a year. In April of 2014, we moved to Vancouver as a family. We gave up our apartment here. We sold all of our furniture, gave everything away, put everything in storage. I have ample evidence to show you that I did give to my husband's counsel that they were able to review, and I'm so sorry that you didn't get a chance to review it. I apologize, but I have overwhelming evidence to prove that California doesn't have jurisdiction, because my son, and actually my husband, knows that, and that is why, California doesn't have jurisdiction, because the child has to be in the state at least 6 months prior to the beginning of the proceedings, and my husband knows that. For the past year, anytime we've ever gotten into an argument.
Before you go on,
I apologize.
The court is not going to address the issue of jurisdiction. The court has jurisdiction. The petition was filed. The response has filed. So the time has come and passed for you to file a motion to quash, challenging the court's jurisdiction. So the court has jurisdiction. I'm more concerned that counsel stated that on June 5th, 2015, the court made orders for you to return to the United States with the child and to release the child's passports and the visa to the petitioner and to return the child to the petitioner. Now, I just heard you say that you did not see, in your opinion, adequate notice of this court date. So you could not be here on June 5th, 2015. But my question to you is, when did you receive notice of the court's orders that it made, and why didn't you comply?
When I asked my husband what happened at the hearing, he said, "It's not good and you'll find out. You're in a lot of trouble." He never told me what happened.
Okay, so when did you find out?
I found out
Did you get a copy of the court's order?
when I came to California last week and worked with this nonprofit. They went to the court. They pulled the file to find out what happened because my husband did not want me to come to this hearing. I needed to come here and find out what happened.
Okay, so you came to court and that's when you found out the orders that the court made?
Yes,
And around what date did that take place?
that would have been over a week ago, Tuesday, when I got here.
So June 9th or June 16th?
When did I respond? Because I did it as quickly as,
Your response is filed stamped June 17th.
then it would have been the day before.
Okay,
What date is that? Whatever the Tuesday was.
so June 16th. So that's when you found out the court's orders, June 16th?
Yes,
Okay. And you found out by way of talking to the petitioner, and he said you will find out, and then you had to fly here and
yes.
do the research yourself? Okay. Counsel wish to respond regarding notification of when the respondent received notice of the court's June 5th, 2015 orders?
Yes, Your Honor. Immediately, the ex parte orders that we received were on Friday, June 5th, and my client immediately made arrangements to go to Vancouver with the original order. Arrangements were preliminary or were made. He did not contact law enforcement up there and was under the belief that he would be able to go up there to Vancouver and meet up with an officer. And an officer did actually meet him at the train station.
Train station?
But then apparently a supervisor said that he would need to essentially domesticate the order there for Vancouver Police Department to enforce it. So I know that a process server was attained. Service attempts were made, but they were, even though there was verification, she was home, service was not made. And so my client went to the Vancouver court on Monday, June 8th, and basically it sounded as if everyone was telling him that you need an attorney to go through the procedures to domesticate the order. And so I just said that we would need to serve. So we served by email. And I filed a proof of service of that. Let's see. It was filed June 10th, 2015. We emailed respondent, and also service was made on June 10th. The ex parte documents and the necessary blank forms were served on Marieke Randoy at 68 Citadel Parade, number 2006, Vancouver, BC, Canada. V as in Victor, 6B as in boy, 1W6. It was emailed, and I also believe it was sent regular mail as well. That was June 10th.
Okay.
And I did email respondent. Let me find out when she did respond to me.
Okay, so essentially she received notice after your client attempted to go directly to Canada and effectuate this order?
Yes, he did go to Canada, correct.
Okay, and it was after that the respondent received notice of the orders?
Yes, but again, with the understanding that he went up there with the intention and advice to have her served personally.
Okay.
But then the police wouldn't do it because it wasn't registered in Canada. The process server was then retained, but he was unsuccessful. So we did the next best thing, I guess. which is email and mail.
And were you aware that he was in Canada at that time?
No,
Okay, so, and then you learned, and then you came to California and you learned of the court's orders. And then that's when you filed your response. Okay, so now I understand. And I understand why the respondent did not comply, okay?
Well, I'm sorry, Your Honor, that it only explains why respondent didn't comply until June 16th, when she finally got knowledge of the orders. She's in Los Angeles. Petitioner is in Los Angeles. I'm assuming Hunter.
So there's still no compliance?
Yeah, there's been no compliance at all. That's what I'm saying. First and foremost, that's the big issue here. That's one of the big issues here. That's the biggest problem. She's here apparently since June 16th, presumably with Hunter and with knowledge of the orders, and is coming to court today asking for affirmative relief while not in compliance with any of the court's orders.
So on June 16th, when you learned of the court's orders, is there any reason why you didn't comply at the time?
I responded as quickly as I could because I know that was the due date, I think. The 16th for me to reply was the last moment that I could. So that's when I did. My son, I did not want my son to be caught in the middle of this. I have text messages to show that if he really wanted to see his son, I wanted to get on a plane. He could have seen him a few hours later. The point is, he didn't want me to come to this ex parte hearing the next day. He did not want me to come. I've had $200 from him this whole entire month. He's frozen me out, no money, nothing. He has been, this is pure harassment. He says that I fled to Vancouver. I went home. We live in Vancouver. I could give you, we have established a residence there. In fact, it's the only residence we have. He lives on a boat. When I was here
A boat in Vancouver or a boat here?
in Marina del Rey, there is no suitable place for us to stay. In fact, for the time that I was down here, he continued to say, this was before he served me, if you go back to Vancouver, I will charge you with kidnapping. My son was very sick, so I stayed. I couldn't even get on a plane because the first weekend that he was with his father, he got rotavirus. I was staying with my friend. We had no place to stay, so I was staying with my friend, Liana, basically just sleeping on a couch. During the week, I nursed my son back to health, gave him back to his father, and he got reinfected. He doesn't bathe him. 3 weekends in a row, my son was sick as a dog for a month. It was so stressful to have my son. We were housebound. I couldn't take him anywhere. But he knew as soon as Hunter was going to be okay, I was going to go back home. But by 3.5 weeks, he served me right when he was going to take Hunter for the following weekend. I've never denied access. In fact, I want to sort this out as quickly as possible because I want him to be able to see his son, but it has to be supervised visitation because the last time he came to visit, there was an altercation and he was violent, and I have photos, and I'm very fearful of him. He is incredibly controlling and manipulative. I have text messages days before I went back to Vancouver saying, and I even emailed his counsel begging him to please talk to my husband and let him know that threatening me and everything else is inappropriate when we're going through a divorce. You know there is no emergency. This is the whole thing. For an ex parte, there has to be an emergency, and there was no emergency. He was using our son as a little pawn, and he was incredibly vindictive and abusive, and he put me in a position where I had to do what was best for my son. I always put him first, and this month, all I've been doing is trying to obey court orders, but also not be tricked by this guy, because he tells me about a hearing with less than 24 hours notice, but then won't let me get on a plane. And then I've got someone knocking on my door, and I'm like, well, okay, a decision happened in court, but I didn't even get to be there to defend myself. Do you know what I'm saying? And then all of a sudden, and I don't know what it's going to be. Am I going to be arrested? He won't reply. It's an intimidation tactic. He's been using it for over a year now. Every time we have a fight, he will bring that out. And I have plenty of documentation to prove it. He's using this ex parte thing because it's the only way that he could get out of the fact that California wouldn't normally have jurisdiction because we live in Vancouver. But he wants the jurisdiction to be here, so he created this thing. And it has just been an absolute nightmare. And I've tried my very best to put my case together, and I enlisted the help of my friends to take care of Hunter and give him a good summer. And I'm just trying to protect him from all this nonsense because, Your Honor, I want to divorce this man. There was no emergency. There is no direct reason why he had to take Hunter right away. I wanted to go through a divorce. If he had any issues with anything like that, if I was supposed to come back to California, then you, Your Honor, would have told me so at the regular hearing. But to throw an ex parte hearing just immediately, it was just a way to be controlling, be manipulative, and intimidate me and cause me great hardship and stress, just untold stress. And I have tried to recognize the court, and I put a lot of work into this case to defend myself because being charged with a felony, it's very serious. That's kidnapping is a felony. And I'm very upset that my husband would go that far to try to force me to move back to California, and that he's using our little son as a pawn. And it's completely unnecessary.
Thank you. Wish to respond?
Thank you, Your Honor. So on May 21st, 2015, respondent was personally served in Los Angeles County with the summons petition. There was an exhibit or two that was attached to the ex parte. The June 5th ex parte, which shows that she acknowledged receipt and she understood the standard family law restraining order. The petitioner last saw Hunter on May 26th, Tuesday. The last time he physically saw Hunter, May 28th approximately. It was either on or immediately after respondent then left Canada. It was either the responsive declaration or memorandum of authorities that was filed today. She admits that petitioner would not sign a travel authorization allowing Hunter to go to Canada, but she did it anyway. So there was no consent for Hunter to go. She admitted that she heard a knock on the door, and she said that she was afraid of the results of the hearing. So I can implore the court to draw an inference of that she was evading service. What I'm hearing from respondent is all about respondent. It's all about respondent. It's not about Hunter. It's all about respondent. It's not about what this court ordered. You just heard respondent tell the court that, look, I will do whatever the court says as long as it orders it. And then when the court does an ex parte order, well, the respondent doesn't want to comply with that because it wasn't an emergency. She wanted the order to come from this court at a regular set hearing. It's been over a month since petitioner has been allowed to see Hunter. We didn't even know if she would show up to today's hearing. She's been here over a week, and if C's so concerned about petitioner seeing their son, I would think that some effort would have been made to connect the two, but it was not.
Okay.
Unless the court wants me to address any other.
I do. On April 1st, 2014, did the petitioner lease an apartment for him and for the respondent to cohabitate with their son in Vancouver, British Columbia? Yes or no?
Yes.
Okay. And that was while the respondent pursued a career in arts in Canada?
Yes, we had,
Okay. And was it your plan, the two of you, for you to sell your belongings and property in the state so that you all could move to Canada?
if she was to have any success at what we were doing,
So that's a yes.
she needed to take she needed to replace my income So that was a yes. That was a plan to move to Canada.
No, well,
Counsel, I could hear,
that's fine.
I heard his testimony.
As this court knows,
Counsel, I could hear. I'm asking the questions. So did you guys agree together it was a mutual decision to relocate to Canada?
Your Honor, it was a temporary basis so she could build credits as an actor and come right back to Los Angeles where the Hollywood industry is. She thought because she was a Canadian citizen, she had better opportunities to build a resume.
So you did agree to move to Canada for temporary or untemporary. You did agree to relocate to Canada.
Yes,
Okay. On January 5th, 2015, did you import the respondent's car to Canada?
we started the process because in Canada, they'll impound your car. If it's there for more than I think a month because it has California plates. So we decided either we sell the car and buy another car, or we could just import the car for a few $100s. And it's a two-step process. So I did the first step, and then she was going to do the second step, and she didn't do it. So it's technically not officially imported. It still has California plates.
The point I'm asking, sir, is you initiated that process.
Yes, because she needed a car that wasn't going to get impounded.
Now, on April 10th, 2012, did you and the respondent obtain a certificate of Canadian citizenship for your son?
I did not have anything to do with that, but she said it was good for Hunter for travel purposes. So I went along with whatever the mother was thinking was good for my son.
Okay.
Your Honor, this,
Counsel, please.
okay,
I'm inquiring. Now, on or before April 26, 2015, did your son in fact become ill?
He had diarrhea. He was completely happy and normal. It's just that he had diarrhea, which is apparently this rotavirus thing.
And did the respondent also become ill during that time?
No, it was just Hunter.
Okay. And was he here in Los Angeles when he became ill?
Yes,
Okay. And once he recovered, did he go to Canada with his mother?
when she took him, yes. I had my mother and my friend were here. My mother was here babysitting for me because when I would go to work, normally we would trade. She would come and pick up Hunter and be with Hunter while I was working. I work in the film business. My hours are really long.
So in April, Hunter was sick. He got well, and then he and the mother went back to Canada.
In May, they were here the entire month of May.
Okay. So when did they return to Canada?
When she took him from my mother on the 28th.
I didn't ask what she did. I asked when did she take him to Canada? Do you know what date?
It was, I believe it was the 28th. I think they went to the airport.
What date did you go to Canada?
The 28th.
May 28th, 2015, yes?
there were declarations of James Campbell and Elaine Dots.
Counsel, I read everything. I'm asking specific questions for specific things. I don't need assistance. I've heard from both. Now I'm inquiring, okay? Thank you.
Okay.
So were you aware that she went to Canada?
I was not aware until she admitted it on, I think it was a Saturday or a Sunday, because the very next day, or the same day, once my mom told me that she had come and she was supposed to take Hunter to the park and she never came back, they said she didn't come back. So I started texting her, asking her where she was, where is Hunter? The next day I was off, so I would take him for the weekend again. And she didn't tell me until I think it was Saturday or Sunday that she was in Vancouver. And one of the reasons I told my friend, the court,
Did you pay her rent in Vancouver?
I did. I paid it for this last month of June. I also gave notice to our apartment because it was a temporary basis.
So
Excuse me.
so you're assuming I'm asking all that other information?
Okay,
So you paid rent in the apartment that the two of you shared in Canada in June of 2015.
yes,
Okay, and you had knowledge that she was there at that time.
yes,
Okay. And is it true that the respondent relies upon you financially?
yes.
Okay. So after you paid the rent, did you cut her off financially, her access to the finances?
No, Your Honor, I gave her some more money for food and expenses. And I told her that was the last month that I was going to pay for the apartment because she needed to come back here. I also said that we would get her an apartment here. It's just an apartment. It's not like it's a bunch of real estate that we need to sell. We'll just get a new apartment. She just needed to come back here because I needed to be with my son.
Once you gave her notice of the ex parte, did she ask you to assist her financially in being in court?
She did not. She said, well, if I could respond to that, when she said I didn't give her money for a ticket, I did. I said, okay, I'll get you a ticket. This is all via text messages. So I have all of the texts from it. And then she said, hold on, I may not need it. You know, she was going to get somebody to come in her stead or something. I said, Marieke, look, it's a plane ticket. It's expensive. It's money. So it's yes or no. I said, you could get your own plane ticket. She obviously got her own plane ticket to go back to Vancouver because I didn't give her money for that. I didn't want my son leaving. So wherever she got the money to go there, she could get the money to come back. She'd also said,
I'm not asking any questions. There is no question that the court was asking at this time.
oh, I'm sorry, Your Honor.
So, sir, currently, where do you reside?
I stay on my boat in Marina Del Rey, and I also have a one-bedroom apartment that I stay at my friend's house. It's between those two places.
When you say a one bedroom with your friend, so the two of you share the bedroom?
No, he has a guest house. He doesn't charge me rent, but I don't want to take advantage of staying there all of the time. My boat is one of the things that explained when I agreed to go to Canada. I said, well, I don't need much because my family has it. So my family has the apartment. I'll just crash on my boat. And when I work 18 to 20 days. So really all I need to do is sleep. And there is a shower and a bathroom and everything in the facilities, the boaters' facilities. That was also to cut expenses so I could afford to do it all. I could afford to support them and myself.
So where is Hunter now?
He's with Marky LaPierre, who is our babysitter.
Is he in the States?
He's in Canada at home. He's been his babysitter for the whole time.
Is there any reason why you did not comply with once you realized that the order was sole legal and physical custody to the father, is there any reason why you did not comply with that once you realized it?
Because I begged him to come to the hearing. I begged him to come to the hearing. I wanted to come to the hearing. He could have seen his son within hours, but because he did not want me to go to the hearing, he wanted to set me up, and he did very well. I did not want to put my son in the middle. He lives on a boat. When he was with him for the first time we were here, he got incredibly sick. My husband does not know how to care for a small child. He's clueless. And for the tiny little time in between that 10 days, by the time I got back, think about this. First of all, I don't have enough money, but if I were to do that, I would have had to get the money somehow, but I wanted to do it the week earlier. Do you see what I'm saying? I just didn't want to put my son in the middle of this because this is obviously vindictive. He could have seen his son that night. I wanted to come to the hearing. And so he was playing games with me and intimidating me and kept saying, well, you should have thought of that. You should have thought of that. I've got your arms and legs now, you know? So for me, it's like, oh, no, no, no. I need to get to court. I need to get this judge and tell her my side of the story before I'm going to be, handing my son over, crossing the border. And he's going to be like, what's going on, mommy? I don't understand, because I've taken care of our son 100% responsibility for our son since the day he was born. My husband works 18 hours a day when he works. He works 15 days a month, and he has 5 recovery days because there was so little turnaround for when he sleeps. So he had no plan. I mean, I pleaded with him before, well, have a plan. If you want to visit, if you want to have a 50-50, whatever you want to do, but we can mediate. I have never wanted to have attorneys.
So Hunter is 3 years old.
Yes, he's 3 years old.
Where was he born?
He was born here in Los Angeles.
On April 10th, 2012.
Uh-huh.
Yes.
Yes.
Okay. And you all moved to Canada when?
April 14th, 2014. He was 2 years old.
So for his first 2 years, he lived in the United States.
Yes.
He was a United States citizen.
Yes. He is now a dual citizen.
Okay. Counsel wish to respond? Anything further?
I do want to apologize for interrupting the court before.
I want to reiterate petitioner's position that the plan to move to Canada was temporary. It was to see if respondent could succeed in her career up there. And if not, my understanding, the plan was to come back here. That's why my client didn't sell his boat. He didn't sell all of his possessions. There are still a couple of automobiles and there is other personal property that's here. With respect to just the last one, with respect to coming to the ex parte hearing, I saw the communication between the parties and the petitioner testified to it. That respondent did ask for airfare and then changed her mind and then said, never mind, and then said she would be sending someone. So when we came here on June 5th, we were expecting an attorney to show up, but there was no attorney. There's no call to the court or to the petitioner. And so it seems it would, if nothing had changed really since June 5th ex parte, which is frustrating to me. And I can't even imagine how frustrating it is to the petitioner.
So you just read, sorry, Matt, you're reading the attorney's part.
Yeah, I am. I'm sorry.
It said
My
petition.
apologies.
I know, but
No,
you know what? You're right. There's mistakes in the transcript. Sorry about that.
Yeah.
So
Nicholas,
Nicholas, you want to continue?
I'll
Yeah,
finish
just
it out.
reread it. Sorry about that.
That's okay. So I want to reiterate petitioner's position that the plan to move to Canada was temporary. It was to see if respondent could succeed in her career up there. And if not, my understanding, the plan was to come back here. That's why my client didn't sell his boat. He didn't sell all of his possessions. There are still a couple of automobiles and there is another personal property that's here. With respect to just the last point, with respect to coming to the ex parte hearing, I saw the communications between the parties and the petitioner testified to it. The respondent did ask for airfare and then changed her mind and then said, never mind, and then said she would be sending someone. So when we came here on June 5th, we were expecting an attorney to show up, but there was no attorney. There was no call to the court or to the petitioner. And so it seems as if nothing has changed really since the June 5th ex parte, which is frustrating to me. And I can't even imagine how frustrating it is to the petitioner. My client wanted to just point out that the 1-bedroom apartment that's available to him, that's where when Hunter is in his custody, that's where they would reside. But it sounds as if the houseboat, is it a houseboat?
It's just a boat.
The reason why the 1-bedroom apartment is made available is so there could be a suitable environment for Hunter.
Okay. Well, I'm glad the mother did come to court today because there is a lot that has changed. I mean, the way the papers were written in the ex parte, it just seems like she just took a plane, took the kid for no reason at all, and your client was left totally in the dark. However, as the old saying goes, there are two sides to every story, and it does not matter the length of the time. But in reading her declaration, the established residency in British Columbia, they were there together as a family. He started the process by importing her car. The reason why, and gave reasons why they started a family there. So it's just, her story balances the entire picture, if you will. I mean, unfortunately, when the court is given an ex parte and there is no response, I understand why there was no response. The court is left to believe what is written in the ex parte, because the court's first and chief concern is what is in best interest of the child. And how the ex parte was written, the court made orders based on that. However, now that the mother is present and the court has her response, I mean, if she was present with the court received, if she was present, if the court received the response had received the response on June 5th, the court might have ruled in a different way. So that was changed. She is here explaining that happened. She is here explaining what happened and her reasons why. So I'm not condoning those reasons, but explaining. It gives, again, a fuller context of the picture. Now, reading kidnapping, I'm so sorry. Now, regarding kidnap seems a bit harsh of a word. That's a very strong word because it's an environment. She went, as she stated, and the evidence supports that she went home to a home where the petitioner, the respondent, and the child resided. And he was fully aware that's where they lived. So it's not kidnap in the sense of she just decided to go to China or somewhere, or no. However, that being said, your request, ma'am, to terminate the restraining order, the court cannot do that. The summons, these are called ATRAs. It's an automatic restraining order. Once a petition has been filed, the petition for dissolution of marriage was filed on May 19th, 2015, and that the ATRAs, all parties are bound to. And again, it's something that the court cannot dismiss. It essentially states that starting immediately, you and your spouse or domestic partner are restrained from, 1, removing the minor child of the parties from the states, or apply for a new or